We join here and give the best legal advice you can find here in Central Florida. But just a reminder, the answers given on this show do not constitute as legal advice and do not create an attorney-client relationship. For legal advice, you can call the office at 1-800-DeWitt Law. That is 1-800-DEWITTLAW or 1-800-339-4885. My name is Chris Crawford. With me is Moses DeWitt. He's an attorney with the DeWitt Law Firm and has been practicing law in Central Florida for over 10 years now. Hello, Mo.
Hey.
How are you?
Hey, Chris. How you doing?
Good. Happy Monday. We need to just put that disclosure out there right now. It's not a Monday for those listening. It's Monday for me and Mo. We had to record early this week. You're going out of town again.
Going out of town again. This time, more of a family vacay.
I got to get on your schedule, man.
You know, when it rains, it pours. I mean, yeah, I didn't take a vacation for, I think, 2 years or so. And so now we're just kind of catching up on lost time. So, yeah.
So you're going to San Diego, you
said?
Yeah,
going out to San Diego for a week. So we'll leaving Wednesday, and we'll be back next Wednesday.
You know, that's one place that I've never been that I've always wanted to go.
It's one of my favorite cities. I was there about probably a little over a decade ago, and it's a cool little place.
Yeah, so it's interesting. So me and my fiance were actually talking about honeymoon destinations and possible places, and it's like I don't think we'll do San Diego. We want to go somewhere warm and nice and tropical. But it's funny because when we first started talking about it, she, being from Florida, born and raised, lived in Miami, was like, "Oh, I'd love to do a ski, like a honeymoon up in the Northeast, where we can get like a cabin and do skiing for a day." She's never done skiing, so she wants to learn and try something, or maybe snowboarding, whatever it might be, right? A snow honeymoon,
which sounds lovely until she falls down the mountain all day in freezing conditions and then comes home miserable.
Right? And I was like, okay, like I can do that. I was born and raised up there. I love skiing. It's very fun. It's not an issue for me. However, just remember that it's not going to be like snow like you've seen in Atlanta. That was the only time that she had seen snow. It's going to be like real snow. It's going to be deep. It's going to be cold, like very cold, more likely not, because it's going to be December. It's going to be around the Christmas time anyway. So, as nice as that cabin with a fireplace or whatever you're imagining will be, and, the cuteness of skiing, just remember there's a lot of falling, as you mentioned. And it's just cold. And she kind of like thought about it, and I was like, so from like, you get off the plane, it's cold. You have to get to wherever we're staying, it's cold. Like it just realized that there's a lot of cold transitions, and she kind of thought about it more. It's like maybe I might want to go somewhere a little warm. And I was like, just think about it, because I can still do that, but just maybe focus on all the aspects of it.
Yeah, I made that mistake one time, and we went to Quebec City one year. This is probably 8-10 years ago, something like that, and it was an unusually cold winter. And I think we got there on Christmas Day, and I was walking from the hotel to the restaurant using my phone for directions. And it was so cold that my phone died. It shut down because it was just so cold. And then we were skiing on the mountain, and it was 27 below zero. And my wife, like your wife, isn't a great skier. She was just learning how to ski, which means it takes you a really long time to get down the mountain.
Yeah.
And needless to say, I think that was her one and only run down the mountain, and pretty much stayed inside the rest of the trip.
Yeah, that was my brother's experience skiing too. That's exactly how he went skiing. I like it. I think it's fun, and if you wear enough layers, eventually, like, you get hot, and you actually have to take layers off, which is great. But it is a process to learn.
At 27 below zero,
that's a little too cold.
It's not fun.
Yeah, no.
I can deal with the cold, and you go out west, it's 15, 10 degrees. You wear the layers, like you say. When you're starting to go into the negatives, it gets a little dicey.
There's cold, and then there's wind whipping, face hurting cold, which is what it feels like in negative 27. So either way, we're going to end up going somewhere a little warm, I think, when all's said and done.
Yeah, we learned. So then, because we used to go somewhere every year around Christmas, because things slow down. So then we went south to South America, which is their summer, which was fantastic.
Oh,
you can't beat that.
I'll keep that in mind. Yeah, no, that's what we're doing. Since we're getting married in early December, we're like, oh, let's just do our honeymoon over Christmas, because it's an excuse to not have to deal with any family after having just dealt with all of the family. And we were like, let's just go ahead and distance ourselves for a little bit.
You may have just picked up why we did a Christmas trip every year. Besides, things slow down,
Sneaky. I can learn a few things from you, Mo. Let's go ahead and teach the listeners a few things. We got the alimony bill that is, as of when we're recording, of course, on Monday, is still on the floor, just, hanging out, waiting, because it has till the 11th to get passed through and go up to the governor's desk. But I mean, And does it have to pass through the governor as well by Friday too? Or does it just have to make it like through the legislation?
Right. So it's on the Senate floor right
Senate.
now. So they'll have to pass it before Friday, before March 11th. That's the end of the legislative session. From there, it goes to the governor, and the governor can veto it or not veto it, essentially. So that will happen after the 11th if it gets passed. Now, there's a lot of speculation that's not going to get passed. Obviously, when you're listening to the show, it'll either have been passed or it'll have died on the Senate floor. And we'll bring you can go online, or we'll bring you updates of that, next week on the show as well. But just in case you haven't been following along, once again, there's a bill to end permanent alimony on the Senate floor in the Florida legislature. And, as we've talked about before, I think this is about the third time in the last 10 years or so that this has tried to be, that they've tried to get this passed.
Right.
And so every year it's a little bit different version of the bill, but essentially, the biggest element of it, of course, is to end permanent alimony. And so, right now in Florida, if you're married more than 17 years, there's a presumption in favor of permanent alimony. And I always tell this, the number of years has changed, kind of throughout the course of history. And, it used to be, I think it was 10 years, then it was 12 years, then it was 15 years or 14 years, something along those lines. Now they've got it up to 17 years. And obviously kind of the next step, I guess, is to get rid of it altogether. But I had a client one time who he was a young guy. I think he was like 32 when he got divorced. And he got hit with permanent alimony because he got married at like the age of 20. And so we represented him when he was in his 40s in a modification action because he was trying to get it his wife was trying to get more, or a former wife was trying to get more alimony. We were able to defend that to where the alimony was not increased and was basically left at zero. But you can see in that circumstance, the 10-year rule, it wasn't really fair to him.
Right.
Guy at 30 years old, he still has 35 years of working life left, and you're hit with permanent alimony for much longer than you ever anticipated
or thought was even a reality when you're just young and in love at 20.
And much longer than the marriage, frankly. So obviously,
right, yeah, that's it. Yeah,
he'll be he would have paid alimony. 40 years on a 10-year marriage, essentially. I mean,
which doesn't make any sense.
Pretty crazy. And obviously, that's one set of facts, but those are the kinds of things that are argued and that they try to avoid when they're presenting new legislation. So, in this bill that's currently on the Senate floor, they're going to try to get rid of permanent alimony altogether. They're going to try to limit rehabilitative alimony to 5 years. Bar durational alimony, which just means alimony for a period of time in any marriage shorter than 3 years. And then basically, if your marriage is between 3 and 10 years, you get half the length of the marriage. Sorry. So if it's 3 to 10 years, you get half the length of the marriage. So if it's 9 years, you get 4.5 years of alimony. If it's between 10 and 20 years, you get 60% of the length of the marriage. And if it's over 20 years, it's 75% or 3/4 the length of the marriage. So again, they're putting a formula on it. It's no longer at the discretion of the court. Right now, the legal standard is need and ability to pay. And then the judge has discretion depending on the length of the marriage. Like I said, if it's over 17 years, there's a presumption in favor of permanent alimony, which basically means it's pretty much always going to be granted. If it's between 7 or 17 years, that's durational alimony. And, it can be up to the full length of the marriage. Most judges, I say, usually take it around half the length of the marriage, sometimes maybe a little bit more. So that's where it is right now. If this passes, that's where it could go. But the big problem, as we've discussed in prior shows, is they put a bunch of other stuff into this bill.
Right.
And so the most problematic aspect...
They stacked it like the uninsured motorist coverage.
Yes. That's a different topic for a different day. You're confusing everything here. But the problems which we've discussed before with this bill is they're making it retroactive, which means if you currently have a divorce decree in the state of Florida, which statistically about half the people out there listening right now probably have, if you're paying alimony on that, this bill, if it passes, would affect that, which means it alters the contract, it alters the court order that you have between you and your former spouse. Now, a lot of people find this problematic because when you entered into that agreement, typically there was some bargaining going on, assuming it was an agreement rather than a court order.
Right.
Obviously there's two ways to end a divorce. Either you guys reach an agreement or the judge makes a decision for you. The judge enters a final judgment. So assuming you entered into an agreement, there was certain bargaining that went on to enter into that agreement. So, for example, maybe you agreed to pay a higher amount of alimony for a shorter period of time, or a lower amount of alimony for a longer period of time. There's often back and forth negotiation that goes on for different reasons. It depends on your own individual circumstances. Well, if this bill passes, then it could impact all of those divorce decrees. So, one of the biggest ones is typically if someone's going to pay non-modifiable alimony, which means, even if you lose your job, you're not allowed to modify the alimony. A judge can't order that. The only way you can get that is if you agree to it. Typically, there has to be some reason that was done. There's some bargaining power that was done. And usually what happens is you pay maybe a much higher amount for a much shorter period of time. So you say, okay, I'm going to guarantee you no matter what happens, rather than paying 10 years of alimony, I'm going to pay you 3 years of alimony. I'm going to pay it at a higher rate that allows you to get back on your feet and do whatever.
Almost like a front-loaded contract in sports in a way.
Exactly. I mean, that's really all this is. It's, a divorce decree, a divorce agreement, a marital settlement agreement is really a contract between you and your spouse or soon-to-be former spouse. So when the government comes in and rewrites the terms of those contracts through this legislation, a lot of people find that problematic. And it can be problematic for a lot of reasons. And we've seen this in the past. One of the years where the alimony bill was in the legislature, it did die because of this retroactive provision. And actually, I think that's the year the governor vetoed it, was because of that provision.
Right.
So that could be problematic. The other big issue that we're seeing, or that people are making an issue, is the presumption for 50-50 time sharing or 50-50 custody. And the reason that they're saying that could be an issue is because right now, time sharing is supposed to be in the best interest of the child or children. And so the court looks at the factors. They say, is this in the best interest of the child or children? And they make a determination. They make a time sharing schedule, parenting plan based on that. This would change that. This would basically say that we're going to start with 50-50. And then you have to bring evidence to overcome that presumption to sway it to either side. Now, the people who are against this bill are basically saying, well, that means that this litigation over the children is going to become much more litigious much earlier, because you're basically going to come in guns blazing, mudslinging,
right,
bringing everything you got.
Yeah, I think as I mentioned last week, it's almost like, in again, to use the sports analogy, it's like they're both coming in with the 0-0 game and everything on the line.
Yeah. Now, I mean, kind of outside of the pure legal realm here, I do think that most judges, while it's not, a presumption currently, most judges, I think, really do want the child or the children to spend as much time as possible with each parent, unless there's a reason for them not to. And usually those reasons have to be pretty serious, pretty substantial. It has to be, physical abuse, drug or alcohol abuse, mental health issues, or sometimes their job just won't allow them to do it, won't allow the schedule to do it. But I do think judges kind of do start at that 50-50 way already. So while they're making a big deal about this provision, and I understand why, whenever there's a presumption in favor of something, it just means you have to change the way you bring evidence into court. You have to start off in a different manner. It can make things more difficult. But I do think judges, the days of dad having every other weekend just really don't exist anymore, in my opinion. I don't see that anymore. It's much more balanced, where I think most judges really are kind of starting with equal time sharing and then working from there, even though there isn't a legal presumption. Because at the end of the day, when you read those factors, it does come down to what's in the best interest of the children. And, typically having both parents involved is in their best interest.
We got to take a quick break here, but I got a couple hypotheticals that I want to run by you here coming up. You're listening to the DeWitt Law Review. If you want to get in touch with Moe and the DeWitt Law Firm, you can give them a call at 1-800-DeWitt-Law, 1-800-339-4885. Also, don't forget, check them out online at DeWittLaw.com, and always on social media at DeWitt Law Firm. Twitter, Facebook, Instagram, TikTok, you name it, it's there at DeWitt Law Firm. We got plenty more show on the way. You're listening to the DeWitt Law Review, WDBO 107.3 FM and AM 580.
pigs get fat and hogs get slaughtered. We just settled a case for a client for $40,000. Client said they were okay with settling between $25,000 and $30,000, but we wanted to push it to get them the maximum value possible. And this client was super cool. They let us do that, and they got a great result because of that. So remember, pigs get fat, hogs get slaughtered.
And welcome back to the DeWitt Law Review, WDBO 107.3 FM and AM 580, Orlando's news and talk. Just a reminder, if you ever have a question for Mo, you want to send one in for the show, you just email those into ask@dewittlaw.com. That is ask@DEWITT law.com. Mo, we've only got a couple minutes here, so I just have a quick hypothetical of sorts talking about child sharing and time sharing. And I was curious if there's ever been a situation, or you could think of what a judge would do in a situation if a child was like uniquely gifted at something, say it was maybe some sort of musical thing and they were in some sort of big ensemble, or maybe it's a sport, or maybe it's whatever it might be.
Mm-hmm.
And that one of the parents is living in the town that is best for them to stay in for that. It's like the team is there, or the best, facility is there. Whereas the other parent is moving to a place that would limit the child's ability to do that. Could you ever see a judge maybe favoring for the child to stay for just like the child's need to grow this unique gift or whatever?
So that's really a case for a petition for relocation, because that's when one parent's going to ask to move away, right? Move to a different area, somewhere more than 50 miles away, essentially. And one of the things the court's going to look at is what are the opportunities available to the child or children. And so, like you say, let's say the child's just a prodigy violin player,
Right.
and the best violin school in the country is in this place, then yeah, that's absolutely something that the courts are going to look at and consider. We see that a lot in special needs cases as well.
Yeah.
Yeah, depending on the special needs, certain areas have much better schools for that than others.
Oh, yeah.
But yeah, it's absolutely something that the court would consider.
I would just be interested to see, even if it's not in the, like if they're within the 50-mile radius still,
Mhm.
but the other, because of the distance, being able to take the child to that school becomes a hindrance or a problem, in which case they might say, hey, we got to put more of we got to have the child spend more time here because it's just necessary.
Yeah, that absolutely comes into play because, again, 50 miles is, can be an hour to an hour and a half
it can be a drive, yeah.
Right. So then in those kind of special circumstances, you're kind of left with the option of, okay, one parent's either going to move closer to the school to allow for the transportation. One parent's going to do more of the transportation. They're going to have to meet halfway, or we're going to have to modify the time sharing schedule to minimize the time that the child's in the car.
Okay, there you go. Just a little question that I had. And
Yeah.
if you've got a question like that, go ahead, send them in, email them to us, ask@DeWittLaw.com. That is ask@DeWittLaw.com. Plenty more show on the way. The DeWitt Law Review on WDBO 107.3 FM and AM 580.
So I got a call from a guy last night who was in a pretty bad car accident. He was behind a work truck, essentially. Some items fell off the work truck, went through his windshield, smashed up his windshield, and hurt his hand really bad. So the insurance company reached out to him right after the accident, and he was at first concerned about getting his windshield fixed. I know that doesn't make a whole lot of sense, but his hand was all banged up and really needed to see a doctor about his hand, especially because he does construction work and that's kind of his livelihood. But he was concerned about getting his car fixed, getting it back on the road so he could start driving. So the insurance company sent him some paperwork, and he signed it. And the problem is that paperwork was a release. So basically, he released the at-fault party from any and all liability for a little over $400, basically, which means he can never go after them again. So he called us to see if we can help them. Unfortunately, in this case, we can't help him. He released the other side completely, and frankly, there's nothing we can do. And that's why it's always so important that you speak to an attorney before you ever sign any paperwork with the insurance company. Worst case scenario is the attorney's gonna say, yep, you're good to sign it, good to go. Worst case, or best case scenario, it'll save you from something like this. So before you ever sign a release, before you ever sign any paperwork with the insurance company, reach out to an injury attorney. Most injury attorneys won't charge you a dime to talk to you and take a look at that and try to help you with it. Unfortunately for this individual, it's a little too late, but hopefully somebody else out there can learn from his story and hopefully avoid making the same mistake he did.
This is the DeWitt Law Review, WDBO 107.3 FM and AM 580, Orlando's news and talk. We appreciate everyone tuning in and joining us here on this Sunday. If you have any questions about anything we've talked about on the show, don't forget you can send us an email, ask@DeWittLaw.com. That is ask@DeWittLaw.com. Shoot us an email, ask us a question about something we've talked about or just any legal curiosity you may have. Also, the past shows where we've talked in depth about this alimony bill from start to finish, each step of the way, the entire process. You go back and listen to all of that. You just got to check them out on Facebook at DeWitt Law Firm. The past episodes are there. Also on YouTube as well and in podcast form where you can find your podcast. But in the meantime, Mo, let's go ahead. You've got a little interesting update and news story about insurance rates here in Florida.
So we've been covering a little bit about some of the roofing insurance reform bills that have been going through the Florida legislature.
Yeah.
And so we've also been covering that there have been a number of homeowners insurance companies in the state of Florida that have gone defunct or gone under, with the most recent being Orlando-based St. John's Insurance Company, which I think just went under a few weeks back. So because of that, the Florida Insurance Guarantee Association, also known as FIGA, has now approved a 1.3% assessment on the premium cost of all policies sold in Florida. So what happens basically is when these insurance companies go under, the policies still have to be handled, through the course of their contract, and usually they're turned over to another insurance company to service them, but they have to be paid for that. So these assessments are then assessed on all insurance policies. So this one's going to be assessed on homeowners insurance policies, aircraft, crops, flood, and malpractice insurance policies that are issued throughout the state of Florida. There's now going to be a 1.3% essentially little line item tax on there. That's going to go to fund all these policies that have gone defunct. So it still has to be approved before it goes into effect. But if it does,
and this is to be applied to all insurance coverages and
all homeowners, aircraft, crops, flood, and malpractice insurance. It doesn't apply to car.
Doesn't apply to car. Okay.
Yeah, but a lot of insurance policies will be affected by this.
But so homeowners could expect to see that their homeowners insurance go up by 1.3%.
1.3%. There will be an assessment on all policies, just like a tax. It's going to be an assessment, a line item on all policies that are written in the state of Florida. It should raise about $190 million if it's approved by the Florida Office of Insurance Regulation. So just, something that we don't really talk about or don't really see, there is a consequence when these insurance companies go under or, leave the state of Florida, pull out. Their policies still have to be handled by somebody, and somebody's got to pay for it, essentially.
Yeah, so that could be very, troublesome for a lot of people here, just who may not have anticipated having those kind of price hikes and may not know that those price hikes are coming. When do we know when that will go into effect?
So this is not
it's not official yet.
Right. So the Florida Office of Insurance Regulation still has to approve the assessment later this month.
Okay.
And then it would go into effect after that for all policies written or renewed in 2022. So if it's approved, it'll take effect in 2022, which is now.
Okay.
So,
very, very, very fun. Can't wait for that.
Yeah. But along those same lines, we've seen a number of insurance reform bills go through the legislature this year. We'll bring you an update next week on where all those are. But we've seen a big push this year and last year, frankly, to try to reform, some of the regulations when it comes to homeowners insurance policies, especially the roofing, the re-roofing the houses under the insurance, roofing regulations,
right,
and things like that. There's a couple of bills in the legislature this year. We'll see if they get passed. There was one modified version that was passed last year, so we'll bring you an update on that next week because all this kind of interrelates, The companies are going bankrupt because of these, they claim because of these kind of roofing, the
insurance, the claims.
Well, I'm trying to say this properly.
Nicely,
yeah, exactly. Say it nicely.
Yeah.
But basically there's been
allegedly fraudulent claims.
There's been an influx of roofing claims, which the insurance companies have been paying out a lot more money on. And so because of that, they want some reform regulations on that.
All right. So let's go ahead and dive into some emails. And again, we'll update you on all of that on next week's show. Next week's show, we'll be able to give you a full detailed update on that. We do have some questions here. And again, if you want to send in a legal question, just shoot us an email, ask@DeWittLaw.com. That is ask@DeWittLaw.com. First one here, Mo. I was just driving on the new I-4 express lanes. Oh, man, I'm such an express lane person now. I live in the express lanes now. So much better. Anyways, I ran over a piece of construction equipment that badly damaged my car. Do I have any legal ramifications? I checked it. It's definitely something from the county.
So the most difficult thing with these types of cases is showing who left the debris there. So we actually had a case a number of years ago where one of the theme parks, I won't say which one, was doing some construction. They dropped a light pole onto I-4. Somebody came around the corner, hit it, damaged their vehicle, and they were injured as a result of that. Obviously, there, you know exactly who dropped the light pole, dropped the debris onto I-4, who caused the accident. The issue in these types of cases, they say they have something that proves it was from the county. Well, you're going to have to show who placed it there, right? So how did it get on the roadway? What's the theory of liability? What happened? So assuming you can say, okay, this was in a county vehicle, flew off the back, landed on the roadway, nobody stopped to take any precautions to remove it from the roadway, then you may have some liability on the county for them to repair your vehicle and make those necessary repairs. Whether it's worth going after them or not may be a different story, but if you can show who left the debris on the roadway, then you may have a case. And now that as I'm saying this out loud, I think I may have a case against the county as well, because the other day when I was driving, I hit a very large pothole and had to replace 2 tires.
Oh, wow.
So that was fun. Yeah.
That is a very fun one. That's never a good time. Let's go ahead and move on to our next email here. Let's see. We've got, I'm trying to sell an old guitar for $10,000 in a private sale. I would love to have a guitar worth that much. I have a buyer, but they said they won't offer that much because they would have to give me a 1099 income report. Is this true?
So this is more of a question for a CPA than a lawyer, frankly.
Go ahead, put your CPA hat on.
I'll give you my layman's understanding. Typically, whenever you issue payment to another company, you're supposed to issue a 1099. Is my understanding. So I don't think there's a $10,000 cap or line in the sand by any means. My understanding is I think if there's more than $10,000 in cash, then you have to fill out the paperwork and report it. If you do like a $10,000 cash deposit at your bank or win $10,000 at a casino, I think those are the types of things when you have to do the reporting. But on just a 1099 when payments are made, typically I think you do that for payments under $10,000 as well.
Okay, there we go. That's interesting there. Man, I wonder why that guitar. I wonder if it belonged to somebody. I got more questions.
Guitar. Yeah.
I got more questions unrelated to the legal side of things. Let's go ahead. We got another one. My neighbor continually puts. Oh man, this one's just for my guy Nicky Football. My neighbor continually puts their dog's poop in my trash. I have asked them to stop, but they continue to do so. Is there anything I can do?
So where's the trash can? Do we know?
It does not say.
Okay, so.
Does that factor in? I'm guessing it does because you asked.
Well, I'm thinking along the lines of, if there is a trash can that's at the road, it's in a public area, typically the police or anyone, frankly, can go into that trash can and remove the contents without a warrant. So
really?
Yeah, I mean, there's been a number of litigation over that where basically, people have shredded documents or, put incriminating things in the trash and they roll it to the roadway in the middle of the night. The detective rolls up, takes the trash, goes through everything, brings it back to the station. And they find incriminating evidence in that, and the courts have pretty much upheld that.
But that's a detective, though, right? So, but theoretically, as long as it's on the public space,
anybody can do it. Private investigators have done it. Anybody can basically go through your trash if it's in a public area. Okay. So, using that same logic, if the trash can is on the roadway, theoretically, anyone could put something into it as well. Oftentimes we see dumpsters that say, private use, no dumping, but usually those dumpsters are in a private area. They're not on a public roadway. So I think that's really going to be the difference there. Now, I haven't researched dog poop laws, to be frank, but I think the same line of reasoning would apply to a case like this. Basically, if it's in a public area, you could put something into it or take something out of it. If it's on private property, then you would need either permission or a warrant to go onto that property to put something into it or take something out of it. Otherwise, you could be trespassing.
Oh, so you can't actually, yeah, okay. So, but if it's on the public land, you can just go in and rummage through. But as soon as, obviously, private property. So let's just say that theoretically this is private property. Let's say they're encroaching on the private property side of things.
Right.
What could this person do? Is there anything this person could do legally?
Well,
they could have them arrested for trespassing.
Well, typically they'd be issued a trespassing warning. So basically, the police would issue them a warning saying, do not come onto this property. If you do, then you could be arrested, because that's kind of the preliminary element of trespassing is you have to be formally warned not to come on the property. It can't just be a surprise.
You can't just okay.
So you would have to call the police, have them formally warned, trespass from the property, and then if they did come back on the property, then they could be arrested.
Interesting. I didn't know. I did not know that it was public property and that it was just kind of there, and you could do whatever with it if it was on the sidewalk.
Yeah. So I mean, for example,
morally though, you shouldn't be putting your dog poop in other people's trash. Just going to put that out there.
I would agree with you there. It also may be a little weird if you rummage through your neighbor's trash in the middle of the night.
Also true.
Even if it is on the public roadway. But yeah, if the trash can is back against the house and you have something incriminating in it, somebody can't just come on and to your property and remove it. They would need a warrant for that. Or if the police did that, that evidence could be thrown out of court because it would be obtained illegally. But the second they put that on the roadway, that all goes out the window. They don't need the search warrant. They can just go through your trash and find anything incriminating.
Wow. I never knew that. Very interesting. All right, good stuff there, Mo. Appreciate that. If you've got questions for Mo, send us those emails. ask@DeWittLaw.com. That is ask@DEWITT law.com. Don't forget, stay tuned for the next show where we'll go in, remind everyone what happened with those insurance rates. We'll talk about the alimony bill. So you'll want to stay tuned for that and listen to all the past shows to catch up on everything. You can find those pretty much anywhere you find podcasts. You can find them on Facebook at DeWitt Law Firm. We've got the videos of them with the shows, so you can watch us and listen to us. It's fantastic. Also on YouTube. And while you're also perusing online, don't forget to check out DeWittLaw.com. You can submit a case evaluation there, and also check out past archive shows on the site as well. They've also got a legal blog where you can learn a little bit too. We've got the Mo Pro Tip of the Week right around the corner. You're listening to the DeWitt Law Review on WDBO 107.3 FM and AM 580.
There you go, Crystal. $200 gift card. Congratulations.
Can I get a hug?
Of course, yeah.
I hear you on the news junkie all the time.
Thank you. I'm glad you came out.
Me too.
Thank you,
And welcome back to the final segment of the DeWitt Law Review on WDBO 107.3 FM and AM 580, Orlando's News and Talk. Don't forget, check out all the social media that Mo does with the DeWitt Law Firm at DeWitt Law Firm, Twitter, Facebook, Instagram, TikTok. He posts some great stuff there. Also, don't forget, you can check out the legal blog, and you can submit a case evaluation at the website, DeWittLaw.com. And if you need the phone number, 1-800-DeWitt-Law. That is 1-800-339-4885. All right, Mo, let's go ahead and give it to him. Your Mo Pro Tip of the Week. What do you got for us?
Well, I thought we'd do one this week related to Bike Week because there's a lot of motorcycles on the road in this area and certainly over on the coast. I think it's, the end of Bike Week, this weekend essentially. So, first of all, make sure you're looking out for motorcyclists out there. Be extra cautious, double check your blind spots, all that kind of fun stuff, because there are a lot more motorcyclists on the road today. But if you are a biker, you want to make sure that you're checking your insurance policy and that you have adequate insurance for your motorcycle. And I'm always willing to do a free insurance review for anybody out there. Just email me at ask@DeWittLaw.com, and I'm happy to spend a few free minutes for you to review your insurance policy and make sure everything's up to date and looking good. But if you want to do it on your own, what you want to make sure is that you have a uninsured motorist coverage on your motorcycle. It has to be specifically on your motorcycle policy, not just on the car policy. First of all, you need to have your motorcycle listed on your policy. I've had a lot of people, and actually people have called into the show before and said, "Oh, I've heard you don't need to have insurance on a motorcycle." Well, if you don't have if you don't have your motorcycle listed on the policy and you own it, and you have uninsured motorist coverage on your car vehicle, it's not going to apply to your motorcycle. There's an exclusion. We've had that case happen before, and it's not good. So make sure you have uninsured motorist coverage on your policy, especially because in Florida, the PIP, that up to $10,000 in benefits for you to go see a doctor, does not apply on a motorcycle. It only applies to a vehicle that has 4 or more wheels. So if you're on a motorcycle, anything with less than 4 wheels, you don't get PIP coverage. So typically motorcycle accidents, if you go down, and hopefully nobody out there does, but typically, it's at least a trip to the ER at the bare minimum, they're more expensive. You want to make sure that you have the proper coverage to cover yourself on them.
So I guess because it's got 3 wheels, there's those new, like what they kind of look like scorpion things, even though they're, I mean, like I would consider them more closer to motorcycles than I would consider them to actual vehicles and cars, especially as far as safety concerns go.
Yeah, the slingshots,
That's what it was.
Slingshots.
Yeah,
like there's no PIP coverage on those either because they're less than 4 wheels. So, no PIP coverage on those. So again, make sure you have the uninsured motorist coverage. But for legal purposes, they really look at those 3-wheel trikes, whether it's a slingshot or another type of trike, as a motorcycle.
Oh, okay. Okay, that's what I was figuring. Was good. All right. Well, Mo, that's a good pro tip of the week. And yeah, everyone be safe out there. Bike week. Make sure you be extra careful looking out for those motorcycles because, the blind spots are extra blind when you've got motorcycles. So take an extra second or 2. You should always be doing that anyways on the lookout for motorcycles, especially because our own Laura Lee is a motorcyclist. So she's always out there cruising around.
There you go.
You don't want to run into Laura Lee. Appreciate everyone tuning in and joining us here on the DeWitt Law Review. We'll be back at the same time, same place next week. Stay tuned for an update on that alimony bill, on the insurance rates, everything you need. Also, stay tuned to the DeWitt Law Firm, Twitter, Facebook, Instagram, TikTok, where you name it, they are there. And if you need to give them a call, 1-800-DeWitt-LAW. That's 1-800-339-4885. For Moe DeWitt, I'm Chris Crawford. Everyone have a safe and great rest of your Sunday.
Oh, hey there. I was just staring at this check that we just got for $20,000 for a guy who was hit by a car while riding on his one wheel. The initial offer in this case was just over $3,700. That's well over 6 times the initial offer. And that's why you call Moe.